Yeah.
Really do love to see at all.
So
Because I saw that you do some video things, but you don't do
what you're saying is, do we record the lecture so it's up on Panopto so you can see the lecture? No. And the reason we don't, the reason that we okay. So As usual, this part is slightly different, and we will now go from the break into, I guess it's a seminar, is the best way of explaining it. It's where your engagement with your preparation for the week as to where we are now. And so hopefully you will have prepared today. I cannot stress, if students will say, well, perhaps not immediately because of with the MCT, because the MCT has different requirements. But when you're looking at the exam, students will either perform really well or they won't. It's a kind of an interesting mix on this. And the reason I say this is because in order to perform really well, you have to understand all the areas of the legal disciplines. Therefore, you've got to do the reading, and you've got to understand, and you've got to look at how things apply and how they work. Everything that we do is applicable to everything that goes on outside the university and your studies. And my view is, and always has been, that this is designed to support you and develop you, taking away a distinct skill set which can be applicable in a wide variety of areas. But the most important thing for you right here and right now is preparation and being able to engage yourselves fully and being able to do the best that you can do. Now, as I mentioned to you right from the outset, you've got a benchmark to follow, which is a very high success rate in this module. That can only be achieved by working hard and doing the necessary prerequisite reading engagement. And when it comes to the second part of the semester and it comes to the end of year exam, and yes, you get your exam ahead of the time of the exam itself so you can get to work on it, but you don't take those notes in with you to the exam, and you're handed that exam. Unless you've done everything that I'm saying to you, you will not perform well. And part of this is about how you write. And, sometimes the skills of writing can overtake the content that you're engaged with, and it's how you write. And as I say, I'll see you all on a one-to-one as we get closer with a mock paper where you will be focusing on one question, and that will happen through your tutorial process, but then you will come and see me individually on a one-to-one. Now, the reason and the purpose for that is being able to apply what you have learned, what you have read, what you have been able to understand, and then to give some formative answer to a question, but in a way that I can talk frankly with you about the way that you've written and how you've written something, and whether or not contextually it provides the information that gives an answer which resembles the answer that I'm looking to see. It figures very differently from the paper, but going forward, what you need to be able to do is, with these questions that are put up with you week by week by week, is to go through them. And probably my suggestion would be, rather than writing a full kind of indicative long answer, is probably bullet point all the issues which you think are there. Now, to be frank, the questions that we're dealing with to begin with are reasonably straightforward. They're not complex, they're not complicated, and we are very fixed and focused on how we go forward on them. So each week, I will give you things to look at, and I'll just pull the notes of where we are for this week. You're given self-assessment questions. That means they are what it says on the tin, self-assessment. So you need to go through those and make sure you fully understood and that you've been able to answer what those are. Those aren't things that we're going to be talking about now, because that's why it's self-assessment. What we now look at is we're going to be looking at the questions. And I think it's important that you can then reflect on it. And of course, when you've got the MCTs, they just really develop that knowledge, the knowledge that you've learned, it just brings it in a much more clear depth of detail and clarity. So, without much ado, I'll just close the door. It's lovely to hear what's going on in the real world. There we are. That's if the door will close. There we go. There we are. Oh, it wants to open again. All right, okay, well, we're not going to play that game. Right, okay. So, let's carry on. My first questions are where we are. Preparations for, questions for preparations 1. Okay, now, I just want you to, before I go through the question, I just want to just be clear about something. Now, arguably, in a couple of weeks' time, we could look at this question and we might see it in a slightly different nature, all right? So, do hold on to this fact. In a week or so's time, we could refer back to this in a slightly different way. But for today, because we're talking about a duty of care, and we're talking about negligence, we're talking about proximity, the relationship, the foreseeability, That's where our focus is on and nothing else, okay? So our question is, what statutory rights are there? Goods contract. Well, that's kind of the overview. But what remedies are there if statutory rights under a consumer contract are not met? So we have this car park sign, and it reads, car parked at owner's risk. The owner accepts no responsibility for any loss or damage to properties or persons, howsoever ever caused. Jane, who parks in the car park, is injured, and when she falls down a large pothole when walking across the car park. Her car is also damaged when a brick from the surrounding car park wall falls onto it. Discuss Jane's legal position. Right, my legal beavers, that's what you're going to do. So you're going to give me some really clear advice here based on your acumen and clear legal skills and knowledge as to how you're going to do this. So have a chat with the person who's sitting next to you, and I will ask you some questions shortly. Right then. So, here we have a situation with regards to Jane. And obviously the key thing about this is there is a sign which explains to Jane with regards to her current position with her car. Okay, can I ask, just a straightforward question, show of hands, how many of you think that no liability may arise? Remember the word may, and always hold this to your vocabulary. How many of you feel that liability may not rise in this situation? Oh dear, so I wouldn't be on the receiving ends of you lot then. Okay then, so how many of you think liability does arise here? All right, okay, so we've got a punitive group of you. All right, okay, that's fine. Absolutely. Right, okay. Would anyone like to tell me why they think it may arise? Okay, so we had pretty much everybody. So can I just ask someone in their group what your thoughts were? Now, it doesn't matter. What I'm looking at is input here. It might be correct. It might have elements which may not be. But it's an opinion and an answer. And this is really, really important. Okay, so can I ask somebody down this row here, what were your thoughts on this? Because I did see hands going up there at that point saying, oh, yes, they're liable. Can anyone tell me why they're liable? Yeah, go on then, yeah. Can I just pause you just for a second, just so that you're absolutely right, and I'm not stopping. I'm just making sure everyone can hear what you're saying. So the discussion at this point is that, and please correct me if I'm incorrect at any point, that the starting point here is probably if we're looking at legislation, because legislation will come before case law, and potentially we have the Occupiers Liability Act, yes, and that would support the position that the landowner has with regards to people who are travelling on that land. Yeah, good, okay. Mm-hmm.
They're old, they might have to go and check them and make sure that nobody's falling off. But then, on the other hand, I'm not sure if that sign, that's from liability or not, is it mine? But then this is out of the 2015 thing.
Okay. Right, no, that's good. Well done. Good. There's lots of really good information there. So, we know there's legislation. Okay, so our starting point here is we've got to deal with the facts of the case. Now, the facts of the case are quite straightforward here, in that we have a clear issue. It says, the owner accepts no responsibility for any loss or damage to property or persons, however ever caused, or however soever caused. All right, so what we know from this morning is the courts have an objective test. It must be objective. And part of this objective test comes from what case law might we derive from on this? So we're dealing with what areas? Yeah, go on.
Is it Haley versus London Electrical Board?
Okay, you could use that. Why might you want to use that case?
I think it's because that case referred to like something similar to that.
Yeah.
Where like there was a hole and the
Individual fell down the hole. Yes.
Fell down the hole. I mean, obviously she didn't actually fall down the actual pothole, but she got injured doing that. So that's kind of
Okay, now as a subsection to your answer, I would agree with you. You could use that case to support your argument. It's one we mentioned earlier as well. So we could use that, and if you remember it on the screen, it was the one where we saw the pothole with all those signs, with kind of the plastic cones around it. But who else might we turn to?
Could you use the Consumer Rights Act in this case as a purchaser of a service from the car park?
There's Consumer Rights Act 2015. You're using it as a service to the car park. You cannot exclude negligence because there is a bar within the section of that. You could, yes. So we could argue that the Consumer Rights Act 2015 might put a bar to this. But we want to get deeper and deeper into this. So what will we go to next?
Could use Caparo for foreseeability.
Good. Caparo. Foreseeability. You see, because the first thing we're going to say is, look, I've got a car park. If there's a problem, is it foreseeable there's going to be an accident? Is it foreseeable that if there's a hole that someone will fall down it? Is it foreseeable that if I've got a brick wall and it's not well maintained, bricks may fall off and they may damage? How many of you think it's foreseeable? Good, absolutely right. So now we probably might want to look at Donoghue and Stevenson as well, because what we want to know is the proximity. Is there a relationship? So in here, is there a relationship? And the answer in short is yes, there is. Because somebody is entering onto somebody else's land, and we know that, of course, trespass is a tort, civil tort. This isn't trespass. This is you're allowed to enter the land, but you're entering into an agreement with the landowner. So we know that there is a relationship. Now, of course, if we entered into contract law, we'd be looking at other cases. Thornton Lane is an example of a case, but we're not. We're staying at tort, and we're looking at negligence, and we're looking at consumer positions. So the sign reads, well, we've said that. So we know the landowner or the person who owns it cannot exclude injury or death or damage. We know that because the Consumer Rights Act 2015 supports that. And the Consumer Rights Act 2015 makes it very clear that that is something that has a bar to it. Now, Jane parks the car and is injured when she falls down a pothole. Okay, so if you were defending the car park, whom might you, or what might you say to limit their damages? What might you do or say? Yes? Good. What was she doing? I mean, it was kind of initially, I knew you had the same situation. I was driving down the road and there was somebody who had their iPhone and were like this. They had these big, massive speakers on their head. Well, they were headphones, but they looked like speakers to me. They didn't look where they were going. They were on their phone and were going, ah, yes, 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 yes. Busy main road, lots of cars going, and just walked straight out into the road. Now, if I'd have hit them, I'd be calling on your services, especially after today's session. But if I'd have hit them, what would have been the outcome? Well, the problem is they hadn't fully mitigated their circumstances. They were derelict of duty when they were crossing the road. They knew there was an obligation to do something. And equally, we may think, has Jane done the same thing? It doesn't exclude that there's a hole, because we know it's reasonably foreseeable in the cases that we talked about this morning, and as the gentleman up there pointed out as well, that we have a case that we can rely on. But the reality is that there may be a dual liability here. There may be something where we have to look, have both parties fully mitigated their circumstances. So for Jane, we need to know what she was doing, how she was doing it. We need to know, not was the reasonable man test, because that won't apply to Jane. That will apply to the car park company, but it won't apply to Jane. And the question is, we look at our approach, as we've talked about this morning, about knowledge, skill, intelligence, and adjudged objectivity, which the courts will look at. And they will look at that in the position of the car park owner, because they have that responsibility. They would have, should have, or otherwise known that if there was a hole, that injury was likely to happen or damage to the cars. So her car is also damaged when a brick from the surrounding car park wall falls onto it. So equally, in that point, again, there is a proximity, there is a relationship. Who owns that wall? When you look at situations in tort when there's an accident or something happens, so let's just project it in a slightly different way. The landowner has a car park, and yes, there's a hole, and yes, Jane injures herself. Sprained ankle. Fortunately, nothing else. She leaves her car and she's fallen down the hole. She's wet. She was reading her message, her latest message that had come through on her Instagram account. And quite why she was on that, we don't know. Maybe we'll have to look into that. And then, at the same time, as she was looking into it and falling down the hole, she hears a bang, and that's that brick falling on the car. But that wall doesn't belong to the car park owner. It belongs to another party, which is adjoined. So now, effectively, we have three parties that we are now dealing with. And because that wall may or may not belong to the car park, they equally have the same issues. One, it's reasonably foreseeable if you've got the upkeep on the wall and you've not maintained it, that damage may ensue. Typical case. Let's deal with something realistic. Not that this case isn't. Imagine if you are going past a wall and a wall falls down on you, and we've seen this happen. It's reported in the news quite a bit when people are have been leaning against the wall and it's collapsed, or something has happened or fallen onto them. Under the Occupiers Liability Act, the owner has a responsibility for that wall and upkeep, but also it's reasonably foreseeable that if you don't maintain it, then damage is likely to occur and it could affect somebody else. And you may not be a consumer, it could be a member of the public who is injured. You may have liability associated with that. So again, Jane's legal position, which is what we're really talking about here, is yes, she may have a case against the company. She may have to think really clearly, did she fully mitigate her circumstances? And if she didn't, she may find herself liable or for partial aspects of this. If it could be seen that it wouldn't have happened had she not been on her phone, then potentially it may be argued that the position of the relationship is different. So, I've said already it's an objective test and it's applied by the courts, and we're looking at knowledge, skill and intelligence of the defendant are judged objectively, meaning did he expected or was he to possess intelligence and general knowledge of a reasonable person at the time the event occurred. Okay? And so, when we're looking at the company, that's certainly going to be looked at in scrutinised, and they will be the defendant. Okay, and it's going to be a very, very high benchmark. It's not, for them to escape that liability. I've also put here the Consumer Rights Act 2015, where we've got an exclusion on restriction of negligent liability, and these are ones we've talked about this morning. Subsection 2, a trader, and subsection 2 again, where a form of consumer contract or consumer notice purports to exclude or restrict a trader's liability. They can't. Now, look, I'm going to be really frank with you. I want you to look at the Consumer Rights Act. Please do that. Okay, get an understanding of it, not an in-depth knowledge, not a knowledge. This module will not test your understanding and sections of legislation, because where that may apply, you will be provided it. You will be tested on case law, much more so in the second than the former class test. Okay, the class test is not designed to have the carpet pulling it from underneath your feet, but you will need to have that real clear knowledge when it comes to the second part. Okay. Before I do that, any other questions that anybody may have with regards to that question? Yes.
Perhaps it's a bit late to ask this, but what if the car park was not commercially, it was not of commercial interest, it was just public, perhaps, was available, there's no fee or any price to it? Would consumer rights be...
If there was no consumer contract that was entered into, or there was no contract that was entered into, and it was a private area of land, then the Occupiers Liability Act would kick in, and there would be a duty of care if individuals had access to that. Okay? Yep.
So essentially, whenever we see signs that says "use at your own risk" or this or this, it usually just doesn't mean anything in the eyes of the law.
Well, it does, but there'll be more on that coming next week and the week after. So, because what we're dealing with here is we're dealing with a contract, okay? So if you enter into a contract and you agree terms to that contract, you may have some liability which may rest with you as the person who's entered into it, because both parties exchange promises when they enter into that contract. But that will become clear. But for the moment of just looking at it from a negligence perception, please just take on board where we are, just with a duty of care and tort, not as the whole thing. That's a good question. Okay, I'm going to go on to question number 2. Question number 2, really straightforward. He says, you can get a bit flustered with the names here, but it is Fred, who is an accountant, is asked by Barry, a client, for advice on an investment he is considering making into AGEC Limited. Fred is not familiar with AGEC Limited or the type of investment Barry is considering making, but nevertheless tells Barry that the investment is sound. Barry makes the investment and subsequently discovers that AGEC is in serious financial difficulties and is likely to go into liquidation. Advise Barry as to whether he may have any legal action against Fred. Now, this is really very straightforward. It really kind of really focuses on what you were doing last week and what we had to do this week. So, quick chat amongst yourselves and let's have some answers, but just a few minutes on this one. Okay, I'm going to get you to pause now. So this is a very real situation. Somebody has given somebody advice. They rely on that advice. They make an investment, and that investment is unsuccessful. And we've got Fred, who kind of has an opinion which is saying, well, he thinks the investment is sound, but doesn't really take it with any degree of seriousness. Of course, things then transpire that they're not what they should be. So let's have a show of hands. How many of you think there is a liability associated with this? Okay, why is there a liability associated with this?
There's the case of Hedley and Heller. That's exactly this situation, and we can use that as case law as a prior case.
Good. Okay, so we can use.
There's a special relationship between the two parties.
Good. And there may well be a transaction that's appeared. Now, let's put it. You've got the information up here. Now, often, I'm going to just tell you something here. When we look at a question, we look at it and we think, and I would absolutely agree with you. So can we just have a show of hands? How many of you agree, although I think you're beginning to note by the tone of my voice there might be an alternative to this, how many of you agree by looking up here that there is a liability that rests with this? Now I've got a considerable less hands going up this time than there were before, but here's the thing. The point that you're making is absolutely clear and absolutely correct. If there was a situation as a client that somebody is imparted advice to that client and they subsequently rely on it because of the, well, we can know that there's going to be a relationship between client and the company itself and the investment, then damages may flow. And your answer is absolutely correct. Again, we're looking at negligent advice or a negligent misstatement or something along those lines. However, what does the situation change if we just remove this situation? And let's put the context in a slightly different way. Just think about what I'm about to say and then just have a quick chat and see. You know, imagine if the situation were Fred, who's having his birthday, invites Barry and a number of other people, and they're all sitting there in the garden having their drinks. And he says, Fred says, "Oh, so Barry, how are you?" And Barry says, "Oh, I'm doing really well, thanks. Yeah, I'm one of your clients, but this is great, lovely evening, really enjoying ourselves. But listen, Fred, I've got a question. I've heard this rumour about X, Y, and Z. Do you think they're a good investment or not?" Now, does that change the situation? How many of you think it changes the situation? Okay. Okay, put your hands up because I'm going to ask you the next question now. No, we won't see your hands now. Okay. My hand, I feel lame. I've got lame. Leprosy has struck me today. Okay. Okay, so just joking aside, so if we have the situation, I'll ask behind you, why do you think that might change, or do you think it's the same?
Because there's a Barry who invited him, he might have known previously that they might be in a situation. That means he's providing what they provide for.
Okay, yeah, I think it's going to be an issue for the courts, you see, because he's still a client. So there is this client relationship. Okay, but the question is to what degree are we going to know? All right, and what degree are we looking at? But if we were to then take the situation completely out of context, and let's say Fred has a business but Barry is not a client, that might change the situation completely because there is no relationship. And you have to bear in mind that imagine if that was this was a situation that did take place. We go to the former one, which is where it's at a party, and somebody else who had no relationship to either of those parties overheard the advice and then invested in it and obviously lost a lot of money. Would they have a case to answer? And the answer, in short, is no, or they may not. We'd have to look at the full facts and details of what was the parties relied on. Now, the reason why this is important is when we look at shareholders in a company, shareholders aren't intimately involved with all the dealings that are going on within the company, and especially a corporate company. And those shareholders and people who become potential shareholders will invest their monies into that organisation based on information which is presented to them. So we have to look at each and every individual situation carefully. We can't actually write anything off without actually knowing really good and full details. But in this case, yeah, I mean, we know he's a client and therefore there is a responsibility that goes with that. So what we would say, there must be a duty and therefore for the defendant to be liable. If there's no breach, you can't have any liability. So we know it's got a proximity test, and we also know from the proximity test, we need to know then when it becomes foreseeable. But the question breached is the standard of care. That is the deciding factor. And has that been reached? It'll be for the court to decide. In any cases that you will write answers to, I do not want you giving full self-fulfilling prophecies in that this person will be liable, this person will be doing this, or this person must that. You won't know. All you can say is they may be liable, but we have to look at all the different factors which may come into play. So the factors to be considered are the likelihood of a claimant suffering harm, potential seriousness of the injury, which in this case is financial, and the cost of making sure no further harm is caused. And of course, this is down to the relationship between the parties. Again, if it was a situation in the first instance, of course, you do have the Consumer Rights Act 2015, which also addresses services which are provided to individuals too. But we are looking at the tortious aspect rather than the contractual agreement and relationship. More on that next week when we talk about it. Okay, I'm going to move on now. With question 3, I have here, what must the claimant prove under the provisions of the Consumer Protection Act Part 1, and how does this compare with the proof required under the common law of negligence? Well, I'm going to answer this, okay, because we have talked about it this morning. Now, what you do need to be really clear about, and I really mean this with real sincerity, that you need to understand when we're talking about common law, we are talking about evolving law. We're talking about case law. We're seeing how that changes. And we'll also be looking at legislation, which obviously is in the first point here, where it says, what must the claimant prove? And of course, we've already looked at that this morning on the slides, and this is just a snapshot of what the Act looks like. So all these points here would need to be looked at in some depth of detail. However, and we know that from the position when we looked at the Mars bar, we know that from the exploding flask, and we know it from the case of where there was potentially goods which might have been damaged, which might impact health and safety. So the other aspect to this is going to be case law. All right? It's the case law which determines. But the facts must be of a similar nature or the same, not different. If they're different, a case cannot and may not apply. So, question 4. Question 4, slightly different. Norma, and I will just spend a bit of time on this one. Norman and his wife Rose are both injured when a vacuum flask purchased by Norman from county stores explodes and covers them in broken glass and hot liquid. The producer is made in Taiwan, but sold exclusively in the UK by country stores under their brand name Solar. They are imported initially from Taiwan by Schwarz Fabrik GmbH of Frankfurt. Examine the potential liability of each company under the common law of negligence, that's case law, to both Norman and Rose. So we'd be looking at in that, we'd be looking at what cases might we apply here, foreseeability obviously being the obvious one, and the proximity in the relationship being the other. And then we look at B, examine the potential liability of each company to both Rose and Norman under the Consumer Protection Act 1987 and the Consumer Rights Act 2015. The second question is a bit tougher. But what I want to do is have a quick chat, because we are time constrained, but have a quick chat, and then we'll look at your answers, and then I'll go through the answer for you, okay? So have a quick chat with each other and see what you come up with. Okay, if you can just make sure, please, that the sheets that I've passed across, if you can just make sure you put your student ID and your name, that would be great. So, here we are. We've got our question here with Norman and his wife. It's an interesting one, this. It introduces other matters that we can look at. And so, can anybody give... Well, let's put those hands up again. How many of you think liability may arise here? Is there anybody who thinks that liability may not arise? Are we absolutely sure? No? Okay, that's fine. Yeah. What's your thought? Yeah.
In the sense that Norman and Rose could have done something and tampered with the product.
Good.
Yeah, in order, well, and in that sense, it's not the problem of the manufacturer or the person that imported it because they created the issue.
Good, well done. So actually, yeah, there is an answer, and you're absolutely right, and it's a defence under the legislation that if somebody does something which they wouldn't expect to do with that product, or they've dealt with it or done it in a way which is different. So let's look at our question. So if we look at our question, we have Norman and his wife were injured when a vacuum flask purchased. Now, what about that Norman, they were going out and they said, okay, now listen, Norman, we're going off in the car today. Do you want a coffee? Yeah, oh, great. Now, I made a coffee earlier. I'll tell you what, I'll put it in the microwave. So they put the pot in the microwave. All right, now, you might think that's a rather silly thing to do. Fact. When microwave ovens first came out, there were propensity for individuals to put animals in there to dry them off. And there was a poodle that was put into a microwave to dry it off because it had been wet, and of course it kind of exploded, sadly. And they sought damages for the loss of a family pet. Of course, consumer law at that time, we're going back to around about the 1970s, late 1970s, was not as it is today. But actually the question was, and the issue for the court was, when you read the instructions, did it suggest that A, animals could be dried off in a microwave oven, or B, this was a use for a microwave oven? And of course, on both counts, the party failed. Now, so what I'm saying is that's a rather sort of rather left field approach to this, but is it not a similar situation that somebody may do something with it, which comes back to your answer, which actually means they didn't fully mitigate the circumstances, they put a product which may say on it, on the label, do not put in the microwave in big bold letters, or alternatively it might be in the instructions. I don't read instructions, I don't do those kind of things. Well, you do. But then you see, if I was to give you a clue, how many of you got Facebook accounts? Hands up, nice and high. How many of you got Twitter accounts? Keep them up, Twitter accounts. How many of you got social media accounts of any description? Put your hand up. All, nice and high so I can see you. And you may only put your hand down if you tell me, hand on heart, you've read all of the EULA documents that go with it. You know, the 999.8 pages. Yeah, you put your hands down. Right, so here we are. We are all in a situation of what may have happened with this microwave oven. We've not fully mitigated our circumstances, all right? Now, where this differs, and I'm just mindful of time, where this differs is something very different happens here. Right, now from our outset, we know the issues that have taken place. We've got an exploding flask. So the question is, who is the liability with? Now the first starting point on this is our chain of causation. And we'll bring our chain of causation, and it starts from that door, and if you recall, it finishes on that door. And during that, our first point is, we know that it was imported from Taiwan by Schwarz Fabric GmbH, who would have liability. They are importing it. They're on that door. And then we have county stores, or country stores. They have liability. They're here. Then we have our couple, our sweet couple, Norman and Rose, who are here. Now, we have our chain of causation, and the question we have to ask ourselves is, at any point, whether it was from the importer, to the store, to the couple was that chain of causation broken, therefore changing the outcome and liability. Because if it was a situation that it was damaged in the transportation and it could be evidence that was the case, we see this, and I'm not a subject I will go into with you, but these are stevedores. Maybe at the ports when goods were being transferred. We have many legal cases with stevedores. They deal with the cranes and the carrying of goods to and fro from merchant shipping. It could be here or that company. If, on the other hand, this particular set of goods was put here, and perhaps there was an accident in the stock room, or there was damage, or there was something else, maybe that liability may be here, or maybe it was down to the couple putting it in a microwave oven and doing something else. The point I'm making is that the chain of causation goes throughout, and when you're looking at something, it may alter or change it. Now, it could be that if something happened at the first point with the importer, then the defence for, as we know through statute, is there's no knowledge. Now, country stores won't have any knowledge of that. Equally, they won't have any knowledge of what they've done with the goods. Okay? And you can come back to almost like Donahue and Stevenson, isn't it? They drank something in a ginger beer bottle, but it wasn't the person that served it. It came from the distributing plant where they bottled it. So the thing is, we have to look at all of these. And when if you were writing an answer like this, you would have to give a clear explanation as to why and how these parties might have some engagement with this as being the issue for them. So, for the Consumer Protection Act and making a claim under it, you've got to think about the following. The first is that the product supplied was defective. That's our starting point. That he or she suffered injury as a result of that defective product. And that is what we know from the outset has happened. But when we're looking at that chain of causation, the claimant must prove on the balance of probabilities that product was wholly or partially caused and the damage that was suffered as a result. And that can be a very hard test because maybe something's happened. You know, I'll give you an example. And in your mock paper that you'll get, this is going ahead of time, we will be talking about this, so you have a mock paper. I will give you a case where somebody is on a dishwasher and where they're putting goods into the dishwasher and they end up suffering an injury. And the question is, was it the person doing it? Was it the dishwasher? Or was there some other prevailing fact that might have happened? And again, these are questions that you need to think about rather than have a readily answer. Then you've got your defences, which we've already talked about this morning, and each of these will apply accordingly. Yes?
When you were saying earlier about maybe something happened with producers and
Yes.
country stores know about it, do country stores not have a duty to know that what they're providing is safe, or should they just rely on that?
They would have to conform to consumer regulations of providing goods which were safe to use. Okay? But if we took that, just taking that one step back, if there was something which damaged on transit, the difficulty that country stores may have is they wouldn't, because it's packaged and they don't unpackage it unless they did that before it was sold, they would not be able to clarify what the position was of those goods. And for their own purpose, and the courts would say, it's reasonable to assume that if the goods are not unpacked, not opened up, and they were opened for the first time by those parties, that they were unlikely to know if there was any damage. And if there hadn't been a product recall, for argument's sake, that would be the case too.
How come you didn't include the manufacturer on the chain of causation? Is it because they're not members of the EU?
Yeah, we're going to Taiwan. So we're dealing with a manufacturer in Taiwan. So therefore the member state may then take the responsibility for it under consumer law. Because it will be easier to bring a case, logically it's easier to bring a case against a member state. And I think one of the points I would make to you, when we're looking at member states and we're looking at cases, this is more of a figurative point, you can bring a case against anybody anywhere in the world, and it can be heard in the jurisdiction of England and Wales. The chances of success can be quite limited, and often that we will look at, in this case, we would be looking at the distributor being responsible here, because under the eyes of the legislation, that's where they would rightly sit. Okay, I'm just going to move on this, because I think, coming back to this question, there are things that we've seen again this morning. I mean, the point I'd make is we go to this third one here, and this story here kind of inspired that question. And the question that we have to ask ourselves here with the taxi driver, taxi driver says, she will sue Tesco after she claims once its coffee fast exploded her hand, she got first-degree burns, and we hear all of this. There was a case 2 years ago where somebody who was going to a pub in Fulham, and this was 2 years ago, went to a pub in Fulham, and there was a marked off area, and they tripped. And they tripped on the marked off area, and they put a case in for, I think it was about £755,000 worth of damages. Psychological injury. Fortunately, they were unsuccessful. But the reason I say this is because where you are dealing with an incident like this, and again, when we're looking at tort, we look at psychiatric injury, we go back to Hillsborough, and we look at secondary victims. And again, you might have an injury which then is almost like post-traumatic stress, which may then occur. So there may be injuries to feelings, there may be injuries which are more substantive than just the burns and the cuts. And in this case here, I can't tell you what the outcome of this one was, just happened to be a newspaper article. But the fact is that if the individual was successful, there potentially may be wider costs that need to be associated with it. However, that court would have just gone through that exercise with what we have just done just now. And it might be that this individual was at the final resting place where they may have done something which may have nullified anything else which would have supported those individuals there too. Okay, right. I'll ask just at the end if I may, because I just want to go on. Okay.
So if you've got a point,
Yeah.
as long as you make it work and give a conclusion with extra points that solidify your argument, or you get the marks in the exam.
Okay, it's a good question. Just for clarity, if this was an exam question, you would have to identify all the parties, the appropriate legislation, which may also include the Consumer Rights Act 2015 as well, and you would need to identify each party's responsibilities and their defences accordingly, and mitigating all areas of each of those parties. And that's what you'd be looking for, rather than just dealing with the end. So it's a good question. So yes, you'd need to have a wider understanding and a wider, demonstrate to the reader that you would have those points. But here's my caveat, ladies and gentlemen. This is just dealing about tort. And when we start going into contract and purchasing, then of course the Consumer Rights Act comes into itself in a wider way as well. So there'll be other commentary that you will need to put on there too. But thank you for that. Right, so on that note, I've just put here, a product is any goods, electricity defined as is. This is the slide that you saw earlier today. The product's defective. The product is as such where people are generally entitled to expect if they don't get what it's there, it can support it through the legislation, and particularly indicates the factors should be taken into account when deciding when the product is defective. You've got your own brand or importer and supplier, etc. So, with that in mind, ladies and gentlemen, this is the moment you've been looking for all day, and you'll go home thinking about this moment. It's our MCT moments, all right? So, now for today I'm going to do things slightly differently. I am going to not ask you to talk with one another. In fact, you must not have any conversation at all. This straightforward question, number one, is as follows. What is the standard of proof required within a civil case? Is it A? Is it B? Is it C? Is it D? Have a look at it. No discussion, please. Just have a look. And then I will ask you to identify the wrong answer, not the right one. Okay, right, now then. So, may I ask what answer you may have had on this one? Yes, yes. Which is a wrong answer? B is a wrong answer. Okay? Why do you think B in itself is the wrong answer, without giving away the right answer? Okay, all right. Okay, good. Can you give me a wrong answer? D. Why is D the wrong answer?
Because it's on the balance,
Okay. All right.
have to be over.
Okay, good. All right, good. So we've got two answers. That gives us, we're down to 50% now. Can I have a wrong answer? Now you've got 50-50 on this. This is a bit of an unfair one. It could be either or. Which is the other wrong answer?
C.
C. So A would be the right answer?
Yes.
Okay, right, okay. Now, interestingly, this, isn't it? Because this is dealing with the burden. This is the test on a civil case. Right, and here comes your answer. Now, we have already said it several times this morning, and here it is. The standard of which it is on the balance of probabilities. Now, be careful. Where C is incorrect is it introduces on the balance of the burden. There is no such thing. Have you heard me speak now on the balance of the burden of probabilities? What percentile? No, so we know that that is not. So the actual test itself is D, okay? So when you're looking at a question, what this is trying to throw at you is you've got two answers there, which it could be. The other two, it may not be. Beyond reasonable doubt, or beyond all reasonable doubt, is the criminal test, so we know that A cannot be there. More likely than not, there is no such thing as a test on that. It may be not. That's not what the courts do. But we know it could be C or D. And it comes down to defined language. You must be very clear on that. Okay, so for the next one, you will be able to speak to the person next to you. Which of the following describes the best describes strict liability? A, strict liability is when a defendant is only liable when he is at fault. B, strict liability is best described when liability is imposed on a defendant without the claimant having to prove any intention, providing, though, that the claimant can demonstrate that the defendant was negligent. Is it C, strict liability is when the burden of proof is reversed and it's up to the defendant to prove that he was not at fault? Was it D, strict liability is imposed on the defendant without the claimant having to prove any intention or negligence on the part of the defendant? Have a look at it. Talk to your next door neighbour. I will ask you the answer shortly. Your sheet that was up there, yeah? Oh, sorry, I've got that one then. Good, that's fine. Thank you. Super. Thanks very much. Thank you. Any sheets? Did you push it? You handed that way. Okay, good. Can I take your sheets? Lovely, thank you. Any sheets down here? No? Did you put them there? Okay, that's great, thank you. Thank you. You got your sheet? Yeah, oh, it's all there. Lovely, thank you. Okay. Okay. How many of you think the answer is B? Have we got any B's in the room today? I never thought I could see myself as being a B. Okay, all right, okay. Good, okay, we've got some B's. We've got any A's in the room today? Any A's? Any C's? Because we know C is yes in Spanish, so that could be the right answer. For all the wrong reasons. No, C's, no. How many D's in the room? Well, this is very good. But maybe not for the right reason. Come on, keep your hands up, please, D's. Okay, can I ask, let's find somebody I've not asked before. Can I ask, if I may, if you're okay with this, can I ask why you thought A, B and C were all wrong and why D is the right answer?
So, only liable when he's at fault, but with strict liability, you're liable whether or not you knew about the incident, so you're at fault regardless, either way.
Excellent, good, yep.
B said you don't have to prove any intention, you just go by the proof and the evidence that's there of the incident. So you don't have to actually prove anything.
Okay.
For that case.
Good.
And then C is the defendant doesn't have to prove prove he's not at fault because of strict liability or at fault. Either way.
And the burden of proof is not reversed. So we don't have that as a situation. Good. Okay, so you're then left with D. And of course, yes, strict liability is imposed on a defendant without the claimant having to prove any intention or negligence. It reminds me of a case. A police officer was caught speeding through a camera. I started off with that earlier, so I'll continue it. Was caught going through a speed camera. In their defence, strict liability meant that they would be imposed a necessary fine. Until the police officer said to the court that the colour of the speed camera was an off grey and not the colour as identified in the highway code. Therefore, it was not a legal binding speed camera and therefore did not have to pay the fine. Case dismissed. Right. Okay, right, next one. So just to show you the answer, sorry, to be absolutely clear, D, of course, is the right answer. So well done and thank you for your reasons. Right, question number 7. Which of the following best reflects the legal position? Now, I mentioned this to you earlier this morning, and I asked you at the time to bear in mind and to hold on to your thoughts very carefully on this, because it's really quite important. We're dealing with consumer legislation, we're dealing with costs associated with it, and this is incredibly important. So, what best reflects, or what is the following statements best reflects the legal position? A, it's correct to say that the legal position regarding property losses which are recoverable under the Consumer Protection Act 1987 are damages to private property over £275, but not damage to the product or to the business or privately owned property. Is it B? It's correct to say that the legal position regarding property losses which are recoverable under the Consumer Protection Act 1987 are damages to private property over £275, but only damage to the product or to the business property where strict liability can be imposed. Is it C? It's correct to say that the legal position regarding property losses which are recoverable under the Consumer Protection Act 1987 are damages to private property over £275, but not damage to the product or to the business property. Or is it D? It is correct to say that the legal position regarding property losses which are recoverable under the Consumer Protection Act 1987 are damages to private property over £275, but not damage to the product or to the private property. Okay, there is your answer. All saying something so similar. And that's the knack here. It's saying something similar, but have you read the content, the minutiae in the smaller detail? Have a look, have a quick chat, and I'll ask you your answer. Okay, time's up. Now then, how many of you think the answer is C? How many of you think the answer is A? A's not been very popular at all today. How many of you feel the answer is B? And how many of you feel the answer is D? How many of you are not really quite sure, looking at the question, which answer it might be? If there was another one, it might be any of the above. Yeah, okay. All right, so... right. Okay, well, this is all about minutiae. It's in the eye of the detail, okay? And what we're looking at here, the answer in this, along here, is correct. It is C. And the reason why it is C, and we'll just bring it up so you can see it, is because of the following reasons. Remember, in order to make a claim, there are certain prescriptive positions that have to be in place or not, as the case may be. So the reason why this is correct is it's damages to private property, which is over the value of £275, not under it. It does not include the product itself, and it may not be a business property. It is the damage that it does to other things. Anything other than that is not what the legislation says. Okay? Well, ladies and gentlemen, we are now at that final time. Now, before we depart, which we will be doing shortly, it's really important over the course of next week. The notes will go up today for next time. It's really, now I'm just going to give you a heads up on something. I have privy, which is quite exciting really, I have privy to knowing what you're looking at on Surrey Learn. And it tells me, each of you, how long you've looked at something. Isn't that awful? Anyway, so the point is that I'm going to make here, and it's a very, very important one. There are some materials up there. There are some materials up there. So for instance, if we take Hedley and Byrne and how you find that document, I would suggest that some of you in this room need to go through that exercise, for it will become important over the course of the next few weeks. Remember what I said to you about insight. Of course, as always, if there's anything you want to catch up with me about, or you'd like to see me, then please don't hesitate to send me an email and we'll arrange a meeting. Otherwise,